Okay, so we are just ready to start, and our first session will be headed by my colleague, Professor Michael Birenak. Michael Birenak is the Associate Dean for Research at Buchman Faculty of Law in Tel Aviv University. He is a returning speaker in our conference and even a returning head of a chair of a session. And with a very accurate way of managing his session, I've promised him that his session will start not later than 9:30, so the stage is yours.
Thank you. Thank you. No need. Good morning. So let's begin with the contents. Thank you for the organizers for having this event. So it has been a tremendously exciting year for privacy. Of course, GDPR. Nobody has not heard of the GDPR, of course. All of us have received numerous updates for privacy policy. Is there anybody in the room that has actually read even one of these privacy notices? One. Okay, the professor's in the room. Okay. And of course, we had the Cambridge Analytica scandal, to which we will return later on. Over here in Israel, there have been new data security regulations that came into effect also in May, the same month as the GDPR, and this has also been a cause of excitement among the privacy circles, at least over here. So our session will discuss some of these events and challenges, which are both internal within cyberspace and also external. And we have these internal and external forces at play in the design, that's the technology, in business, and in the law. So our three speakers, myself included, we are all lawyers. I will present them briefly, and you can look them up in the program and on the website to learn more about them. Each of us will have some 20 minutes, which will leave us a few minutes towards the end for some Q&A. And because we have presentations, so we will be doing it from the stage. And the other two will be sitting there. Karen? Are we session one? What an honor. Okay, so we'll just present our speakers briefly. Our first speaker will be Professor Ari Waldman. Ari is a professor of law and the director of Innovation Center for Law and Technology at New York Law School. Our second speaker will be Dr. Tomer Shadmi. Tomer is a postdoc at the Blavatnik Center for Cyber Studies and at the Safra Center for Ethics, both, or not both, but at the law school. And Yaniv has already presented me. So Ari, the floor is yours to begin, please.
Boker Tov, and we can do the rest of this in English, though. Thank you very much. It's an honor to be here. Thank you very much, Michael, and to everyone, all the organizers of CyberWeek, as well as the academic portion of the conference. It's a pleasure to be here, and it's a pleasure to start off this day. I'm looking forward to all of these exciting presentations from people far smarter and far more educated about this than I. So let's move to presentation mode. Okay. So my name is Ari Waldman. I'm a professor in New York, and I work on technology design. I have a PhD in sociology, so I'm less of a tech person and more about how technology mediates our lives and how technology affects us on a daily life. I'm going to talk a little bit about how privacy law and privacy norms get implemented on the ground. When we talk about privacy law and cybersecurity law and regulations, we normally think about statutes, we think about case law, we think about rules that are set down, like the GDPR, for example. And privacy by design, this idea that privacy should be baked into the DNA of technology products and a responsibility of data collectors, is part of the GDPR. It's Article 25 and Recital 78, ostensibly part of the GDPR. But these rules and we experience this in other areas of law as well, don't always get implemented on the ground. So I wanted to explore why that is. So as a good academic, I'm going to start with my argument for the day. I'm going to argue that, and this is based on an article that's already been published in a future book that's coming out that's just been accepted for publication. I'm going to argue that the vision of data privacy that gets embedded, data privacy and security, that gets embedded into the technology products that we use every day, from our phones to websites to the processes of data collectors, is far narrower than what chief privacy officers may want, or far narrower than what the law may want. And that's because there are other people involved. CPOs and lawyers and justices of the Supreme Court do not design any technology that we use. The people that end up designing the technologies are engineers and technologists who are on the ground writing the code. And the people who are on the ground actually working to help companies that help data collectors and technology product designers comply with the law are not always their legal departments. They are outside vendors. One of the things that the GDPR has done is helped create an entirely new ecosystem of third-party vendors, from cloud support to lawyers, that support corporate compliance obligations when it comes to the GDPR and other laws. So it's very much more often, I argue, the vision of data privacy from the designers themselves and the third-party vendors that ends up getting implemented on the ground. And that's problematic for a couple of reasons. And I think that transforms privacy. It either will make privacy a lower priority, as it is for many technology product designers, or it will turn privacy into mere compliance, check-the-box based system. So for a few minutes, I'm going to talk a little bit about where this research comes from and then some implications. So a little bit of background first. In 2010 and in 2015, Ken Bamberger and Deirdre Mulligan published a book called, or in 2015, they published a book called Privacy on the Ground, in which they argued that chief privacy officers were integrating a forward-thinking, trust-based vision of privacy into the products and platforms that they create. But when I read this book, and I said to myself, that doesn't really accord with my experience on a daily basis. It doesn't really accord with anecdotal as well as quantitative evidence that's out there. For example, does anyone use Snapchat? Okay, some people use Snapchat. It's much more popular among a younger set in the United States. Snapchat is an ephemeral messaging service, although it's not really as necessary now because Instagram has an ephemeral messaging service as well. Snapchat is an ephemeral messaging service that allows you to select the time or the seconds after which your photo or your snap would disappear. Snapchat, this is an example of a screenshot from the very beginning of Snapchat. You have to go through the screen. It's a designed-in part of the app. It gives you this impression that you have control over your privacy when it comes to sending pictures. But Snapchat does not. There are many ways for a picture to remain before it disappears. Someone could take a screenshot. It was also stored on an unsecured part of your computer when you updated or connected your phone to the computer. So if this is designing with privacy, if this is a CPO's, ostensibly Snapchat's, if this was a CPO's vision of privacy, as Bamberger and Mulligan suggested that it was, it's not getting integrated when the product was finally designed. Another example is Uber. Not the best corporate citizen around, but Uber designed its app to track us wherever we go, even after we deleted the app. And that was a purposely done, insidious design tactic, certainly not integrating a pro-consumer, trust-based vision of privacy on the ground. And of course, Cambridge Analytica. If Facebook actually cared about our privacy, if it was designing in tools that protect our privacy as much as Sheryl Sandberg and Mark Zuckerberg say that they are, Cambridge Analytica would not have happened. The entity would not have been able to scrape information on 87 million users just so easily as it was. So the vision of data privacy that Bamberger and Mulligan suggest exists among CPOs, while true, is not getting integrated on the ground. So why is that? Well, a couple of reasons. These are the people that are doing the designing. My esteemed colleague Steve Bolovan, who's a professor of computer science, his students and his graduates are the ones that are doing designing, not the CPOs sitting in their offices. So if these are the people who are doing the designing, then it's much more, I wondered if it was much more important to see what they thought about privacy than just to see what the CPO said. That research agenda started by Bamberger and Mulligan to talk about how privacy law and privacy principles get integrated on the ground is extraordinarily important, but it's incomplete. And also, there are these people, this ecosystem of privacy of third-party vendors that are involved, that help companies comply with their GDPR as well as other legal requirements. These go everywhere from business solutions, from services to technology and information resources, from cloud-based resources, consulting firms, certification, industry analyses. This is an entire industry that is integral in determining how companies comply with the law, not just the CPO writing protocols in her office and integrating those throughout the company. So I decided to spend a lot of time talking to these kinds of people and these kinds of people. So my research design for this project, this is a little outdated, this presentation, involved interviewing engineers as well as lawyers for the design side, observing the product design process of a company, and also having 2 days of meetings with two large technology companies. All of these interviews were done and meetings were done with confidentiality agreements so people could speak honestly about the privacy in their design process. When it comes to the privacy ecosystem and the third-party vendors, this involved some work, some website work and desk research involving categorizing these different vendors, some website research. Also, I am in the process right now of talking to some of the vendor leads, some of the marketing and other professionals at these companies, really just to find out what they do and how they market the materials and how they get integrated into corporate privacy obligations. And this is part of the research that's ongoing. So what are some of my findings? Obviously, there's a whole lot that we can talk about, and I hope we can bring this more out in the Q&A, and when the book is available, you can all buy it on Amazon. So some of the findings from interviewing technology product designers as well as third-party vendors. How did they integrate, and what is their effect on on how privacy is implemented on the ground? So not all. Obviously, this is an ethnographic project. I'm not suggesting that all designers and all technologists feel this way. I think people that get a certain type of designers that get a certain type of education feel obviously differently. Ethnography is there to suggest that a narrative exists, not that everyone feels this way. So I'm not suggesting that every designer or every engineer in the room has this same view. It's a matter of problematizing or questioning whether a single narrative from the CPO is actually getting integrated on the ground. And many of the designers that I spoke to either don't have a conception of privacy or have a very strong conception of privacy, but they conflate it with cybersecurity. They conflate it with encryption, secrecy, security issues that overlap but do not fully encapsulate broader privacy legal obligations. And design teams, many of the design teams that I witnessed and people that I interviewed suggested that design teams are relatively isolated. Privacy in many companies is a separate department. It's like legal or marketing. It's a separate department. And contrary to media reports to the contrary, they operate compliance style. they check the box. Some designer has to say, oh, we have to run this by privacy, much like they have to run it by legal. And in many of these companies, like a Google or a Facebook, high-pressure technology companies that are engaged in highly competitive work, many of these privacy professionals do not want to be in the way of progress. So many things are either just checked off and that don't result in any real privacy compliance. And also, many of these designers work in teams that are homogeneous. Despite any stereotypes to the contrary, most of the people, at least in Silicon Valley, in the United States, who still work for technology companies, small, medium, and large, are still straight white guys. And the lack of diversity among, and not only are they mostly straight white guys, but their bosses are all, and they're all engineers. Their bosses are also engineers as well as their bosses. And the lack of diversity has a negative impact on the integration of privacy into technology products, just because different people think about privacy differently. When you don't have experience as to how, for example, constant data tracking may affect a woman, you don't necessarily think that you're going to integrate those. Don't necessarily think that constant data tracking is a problem. Instead, you think it's pretty cool because you can allow a company for whom you downloaded an app to, when you pass by a brick and mortar store, to give you a notification that, oh, there's a sale going on. Or the lack of diversity has other problems. It means that mobile assistants are going to recognize, or home assistants are going to recognize what to do when you say, I'm having a heart attack, which is an affliction that mostly affects men, but not know what you're going to do when you say, I'm being raped or I'm being assaulted, which unfortunately more affects women. And these are real stories. These are real things that have resulted from the lack of diversity in design teams. Additional findings with respect to vendors, and as I said, this research is ongoing. Vendors are gathering clients by offering one-stop shops for compliance with privacy by design and other elements of the GDPR. After I started this project, after I started receiving tons of emails from these vendors saying, are you worried about your company's compliance with the GDPR? GDPR is coming on May 25th. Hire us and we will solve all of these problems for you. So as a lawyer, I was skeptical of someone solving all of my problems for me. So I started looking into these and realizing that these marketing tools, many of which are about we will solve your GDPR problems, we will do privacy by design for you, is meant to bring people in, and then they're offering, but in the end, what they offer are assessments. Have you done this? Have you done that? Check the box of certain tasks, including hiring staff, as well as having documents that verify your process. So even though vendors are selling themselves, and we can go into more detail about how different vendors from different categories are dealing with this, but vendors are marketing themselves as one-stop compliance shops, and then it turns the GDPR, as well as other privacy laws in the United States as well as elsewhere, into just have you checked the box. What are the implications of this? Well, for designers, security is crowding out privacy. Cybersecurity is really easy to understand. When I give this talk to CEOs, everyone understands cybersecurity. It's in the news a lot. It gets media attention. It gets the attention of senators and political leaders to pass state data breach notification statutes in the United States. These are the things that get a lot of attention. It's also what designers are trained on. Engineering and computer science curricula, when they do mention things like privacy, they're really talking about security. Systems operations classes in engineering departments include security classes. They don't necessarily include more of the social or more of the other things that include privacy. I talked a little bit about the discrimination in design. There are many, not just anecdotal, but serious examples of ongoing discrimination and discrimination against marginalized groups in AI and other technology product design, particularly because the people who are doing the designing are not representative of the people who are using the technology products. And the lack of diversity in design teams also has a contribution to the lack of consideration of privacy on those teams because, as I mentioned, different socioeconomic and different demographic groups think about privacy differently and think about privacy needs in a different way. All of this tends to, and as well as combine this with vendors, combine this and how designers work within corporations, and the third-party vendors that are doing a lot of the work of privacy for companies, large, medium, and small. This may turn privacy and the GDPR into a check-the-box system, where all you need to do, even though the GDPR, although it could have been stronger, has more robust protections than the United States does, can turn this law into a mere check the box, because now a company is giving you this opportunity to say, you have done X, Y, and Z, here's proof in case a DPA comes after you. So what do we do about this? In the last couple of minutes, I'll talk about some of the things that we can do about this, and I hope we can bring out more of them in the question and answer. We need integrated privacy teams, integrated on many metrics, not just demographic diversity, but we also need to integrate design teams among the broader company. There are many designers that I spoke to that only work, eat lunch with, and live with other engineers, which means that they're only going to get a certain perspective on the needs of privacy and the needs of users. There's an extraordinarily important role for design law. Law that not just does what Article 25 of the GDPR says, which is basically just a catch-all provision. It says that data collectors shall use technological and organizational measures to implement data protection principles in an effective manner. That says really very little about design. What we need is DPAs and the Federal Trade Commission in the United States to include misleading design in their regulatory portfolio. So when companies like Snapchat, like Uber, do more than just lie on their privacy policies, but actually code in misleading elements into the design of the product, then regulators can go after them for misleading us as to what our rights are. We need to better educate our designers. We need to educate them not just on security issues, but also about privacy issues more broadly. And I will leave it there. We will do, I think, questions after all of the presentations, right? Excellent. Thank you very much.